So employment tribunals, in this video I want to talk about employment tribunals and three things. Firstly, whether or not you should commence one at all in the first place. Secondly, if you do decide to go ahead, how to do it, in terms of how to get it started off the ground. And thirdly, once it's up and running, a few points about how to actually conduct one once you're in the middle of it. So firstly, whether to commence an employment tribunal claim in the first place, well, these things are not for the faint-hearted, to be honest. They actually can be quite stressful. It depends on your own personal kind of the way that you deal with life events. If you find that, something like a court case could give you a lot of stress in your life, you might want to weigh that as a factor in the mix. If you're quite sort of laissez-faire, a bit carefree and happy-go-lucky, and you think you don't mind a court case, then by all means start one. They are free. When it comes to starting one off, there used to be fees involved. So the only cost to you once you've actually decided to go ahead is perhaps if you decide to instruct a lawyer, which you might need to do if it gets a bit messy in the future. But they're certainly free to start. Then the other consideration here is about, well, what about negotiating a settlement out of court? We are specialists in negotiating settlements out of court. We're also specialists in employment tribunals. We quite enjoy employment tribunals because it's that cut and thrust of the advocacy, especially if you're winning. You've got your day in court. But for our clients, they kind of tend to prefer a negotiated settlement. Okay, that includes a confidentiality clause or gagging clause, which means that you won't be able to talk about your grand success that you've managed to get, a fair deal from your employer. On the other hand, you've saved yourself a year or more even of messing around, especially when you haven't been paid for that entire time. Why not just, a bird in the hand, get a negotiated settlement, and then you can move on with your life. Having said that, sometimes employers just won't play ball. They just won't give you a deal out of court. So in which case you do need to start an employment tribunal. So firstly, you'll need to go through ACAS. You get yourself an ACAS certificate, and you then get often very nice ACAS conciliator, which is a person who will try to approach your employer, and for them they'll approach the employees. So there'll be a go-between, and to try and get the parties to settle out of court. Again, this is not the same as having a lawyer, because firstly, they're not lawyers, but secondly, they're really neutral, and they're not actually working for either side. So they're not going to put forward, just one side of the case, which is what a good lawyer will do for you, make your case look really strong. They're just going to kind of run an errand almost back and forth with a number. Will you accept X amount? Will you accept Y? No. Okay, let's go ahead. Once that process concludes, if there's no deal, then you get your ACAS certificate, entitles you to issue your claim. So the ET1 is the name of the form which you need to use to commence a claim, and on that you fill that in. The details of claim is the part where you're setting out what happened. Now that's the most important part of the whole employment tribunal bundle, which is a bundle of papers, which could be many livre full of papers by the end of a case, or it might just be one file if you're lucky. Certainly that very first document, the ET1, sets out your case. That will really determine the path of the whole of the future of your case. So if you don't put in that ET1 details of claim exactly the right things that you're actually claiming for, you won't be able to go back later on and amend that. Why, I hear you ask? Well, there's a very strict 3-month time limit. So you've got 3 months between the event that happened at work, so whether that's you being dismissed, or whether it's you resigning, or whether it's you being, for example, discriminated against or victimised for whistleblowing, 3 months between that event and the date when you need to have commenced your employment tribunal proceedings. So you've issued your ET1. So then if you issue an ET1, say in June, and then you get to October, you realise you forgot to include something that happened in May, well, by October, it's more than 3 months out of time. So a judge, by and large, won't let you amend your claim at that point. So you just won't ever be able to claim for that. So if you are going to get a lawyer involved in anything, and only just in one part of your whole employment tribunal case, get them to draft the ET1 details of claim document for you, okay? That is the foundation of which your whole case is built upon. So if you are going to be able to splash out, get yourself a lawyer, at least get them to draft that particular document. Ideally, you'd get them to run the whole case for you, and we're pretty successful at negotiating in parallel. So we'll run an employment tribunal case and also negotiate for you at the same time, and that's a bit of a carrot and the stick approach. You've got that carrot, which is that let's have an amicable out of court settlement, and you've got the stick, which is your employment tribunal case, so they kind of see you in court if they don't reach a fair settlement deal. Anyway, once you've commenced your claim, you'll be invited to a preliminary hearing. Now that's often a phone call which the judge will attend alongside normally the lawyer for the other side, because employers normally have lawyers, and yourself. And that's where the case is kind of knocked into shape in terms of the diary. Everyone gets a diary out, puts a date in there for the trial, and then some orders for case management, which are when the witness statements need to be ready, when does further information need to be exchanged, do any expert witnesses need to be instructed. So that's the preliminary hearing. And then fast forward, say, another few months, you'll have the actual trial itself. Now before that, there'll often be a number of applications. Applications are where one side seeks certain information from the other. It might be that they want more detailed answers to written questions, or for example, more disclosure of documents. So rather than just swapping, both sides having to swap their documents, you might have noticed that they haven't given you certain crucial documents or certain emails. You want those. They might argue that they're not relevant or they're somehow confidential. Well, that's called an application. You make an application for specific disclosure where you request from the Employment Tribunal an order that they then have to provide you those documents or that information. Now they can also make applications against you, for example, to clarify your case or to provide them with documents or perhaps written additional information. So that's a whole kind of minefield of events which could take place between the preliminary hearing and the actual full hearing, which is the application stage. Anyway, once you get to the full hearing, that's a trial like you might have seen on TV, except everyone's sat down, there's no jury, it's not very glamorous. It's often a room in Croydon or somewhere like that. But ultimately, you're not there for the glamour, you're there to, win your case and have your day in court. Now, the statistics aren't great for claimants. If you look at these things, it's less than 10% of people who actually win these, partly because I'm not going to say the system's loaded, but it is for the claimant to actually prove their case. So you have to get over this 51% barrier, over the 50% barriers. You have to be 51-49. If the judge sees things as equal, they can't decide who's right and who's wrong, then they're going to have to decide in favour of the respondent, which is the employer. Now, also employers have HR, they have lawyers, they have managers, they'll probably have a number of witnesses. You probably won't have very many witnesses because, your colleagues won't probably want to come to court because they have their own jobs to think about. So you have got a bit of an uphill struggle. So again, really is worth giving some thought to getting a lawyer instructed. Now, if you do decide to get a free initial consultation from us, we'll talk to you for 15 minutes or so on the phone about your case. Often we can't do a percentage or a no-win, no-fee on these types of cases. If it has gone as far as an employment tribunal, we're more likely to offer you a fixed fee, again, perhaps for doing that EC1 at the start, or even an hourly rate if you want us to conduct the whole thing. But it doesn't cost you anything to get in touch. So you should definitely try and get a free consultation and, think long and hard really before you're starting a tribunal. But if you do start one, good luck. Thanks a lot.